Good evening, everyone, and welcome to the first Benjamin Ferencz Lecture on International Criminal Justice of 2025. And apologies to everyone who had registered to be at this event on the 9th December because we had to postpone. But I'm very happy to see you all here with New Year's energy. My name is Gabriele Chlevickaite, and I'm a researcher here in international criminal law, where I coordinate international criminal law-related projects and conduct research into fact-finding in international criminal investigations and prosecutions. In just about a month, we will mark another anniversary since the full-scale invasion of Ukraine by Russia, with human rights violations ongoing on a daily basis. And we hear not only about the violations themselves, we also hear about a lot of initiatives to bring justice for the victims. The efforts by the national police, prosecutors, judiciary, the arrest warrants of the International Criminal Court, neighboring countries conducting investigations under the principle of universal jurisdiction, the Register for Damages for Ukraine opening its doors, and behind it, the many people and organizations that are making it happen. And we have some of them here today. Tonight, we'll have the opportunity to hear about and hopefully to discuss in a Q&A the issue of accountability for forced displacement and deportation of Ukrainian children to Russia, which has been a continuing feature of this war. Our speakers will bring you closer to understanding how Ukrainian authorities are trying to return and reintegrate the children, how civil society is working to document the deportations and forced displacements, and what avenues there are or may be to bring those accountable to justice. And I would also like to invite you to look at the images hanging in the lobby as you will be leaving, drawn by children from Kiev and their imaginations of peace during this difficult time. I promise I will stop speaking soon and hand it over to our esteemed speakers, who I'm pleased to introduce. The first speaker will be Viktoriia Pasik. She's the head of the expert group at the Child Rights Protection Center under the Secretariat of the Ukrainian Parliament Commissioner for Human Rights. She focuses on the search and return of Ukrainian children who have been deported or forcibly displaced, as well as the reintegration of returned children in Ukraine. Our second speaker will be Dr. Marieke de Hoon, who is Associate Professor of International Criminal Law at the University of Amsterdam School of Law. She is moreover Honorary Appeals Prosecutor at the Dutch Public Prosecution Service and Senior Counsel at the Public International Law and Policy Group. In her research, she focuses on domestic prosecution of international crimes, the various cooperation mechanisms that are created and developed to facilitate this, and on challenges related to developing an appropriate victim policy for such prosecutions. We will then hear from Natalia Jasztal, who is a co-director of the International Crimes Investigation Group at OSINT for Ukraine, an NGO dedicated to investigating and documenting international crimes committed in Ukraine. Natalia holds a master's degree in law, with her thesis focusing on international criminal law and transnational criminal law. And she will also talk about a communication to the ICC under the Article 15 of the Rome Statute, which she played a key role in preparing. And last but not least, we will have Deniz Dirisu, who is an OSINT expert, international consultant, and co-founder of OSINT for Ukraine, who specializes in international criminal law and OSINT investigations and in building and leading diverse teams across borders within the context of digital investigations and justice. So that's all for you to have context of what type of questions our speakers might be able to answer after their interventions. We will start with the address by Viktoriia Pasik of the Ombudsman's Office of Ukraine. Viktoriia, the floor is yours, and you have about 10 minutes, then up to 15. Please go ahead.
Okay, good evening, ladies and gentlemen. First of all, I would like to thank Dr. Gabriele Chlevickaite for moderating this session and express my gratitude to the International Humanitarian and Criminal Law Platform and the Embassy of Ukraine in the Kingdom of the Netherlands for co-organizing today's event. The words of the eminent Benjamin Ferencz, who dedicated his life to the cause of international justice, resonate deeply for me. Nothing is more important than ensuring justice for the victims of injustice. These words take on particular significance when we talk about the protection of children during war, especially in the context of deportation and forced relocation. Russia's policy of abducting Ukrainian children was tested as early as 2014 during the occupation of the Crimean Peninsula. At that time, so-called trains of hope were organized to take children for adoption and placement in Russian families. 10 years ago, Russia Federation was not met with the response it deserved as a perpetrator. As a result, today we are witnessing one of the largest violations of children's rights. Recently, the Child Rights Protection Center in Kiev, based on Ombudsman's Office of Ukraine, received a visit from a young boy named Vladislav. Before the war, he had lived in Mariupol in Donetsk region with his aunt. After the Russian invasion, the city turned into a ruin, destroying not only lives but also children's dreams. Initially, the Russians took Vladislav to Volgograd, then to Kursk, where he was subjected to interrogation. He was tortured during these interrogations, later in violation of his best interest of the child, and despite to reunite with his aunt, Vladislav was placed in a Russian family. However, he managed to escape and return to Mariupol somehow as a pro-Ukrainian and free-thinking individual and teenager. He was detained twice by the occupying forces and endured more interrogations. Ultimately, he was rescued. At the same time, we recall the tragic story of two Ukrainian teenagers from the occupied city of Berdyansk, Tigran Ohannesyan and Mikita Khaganov. The occupiers not only denied them the right to reunite with their families, but in blatant disregard of international humanitarian law and the additional protocols to the Geneva Convention, murdered them for allegedly preparing a diversion. To these days, their bodies have not been returned to their families to Ukraine. These horrific crimes show that all children in occupied territories and those deported and forcibly displaced to Russia Federation are in danger. To speak in numbers, about 20,000 Ukrainian children have been deported and forcibly displaced by Russia Federation since the beginning of the full-scale invasion, so since 2022. However, Russian official reports noted that more than 700,000 children taken from Ukraine. And also, just about numbers, around 1.5 million children are currently under occupation, and each day they are at the risk of deportation and forced relocation. Throughout the years of the war in Ukraine, Russia has demonstrated that international humanitarian law and Geneva Conventions are mere utopian ideas for them, and they manipulate these principles with impunity. Deportation is presented by them as a humanitarian evacuation. However, in blatant violation of the Geneva Convention on the protection of civilian person in time of war, especially Article 49, the so-called evacuation corridors are nothing more than death corridors, leading only towards Russian Federation under the sides of Russian military forces. Legal mechanisms that have historically served as pillars of global order cannot stop this process, unfortunately. After the issuance of arrest warrants for Putin, President of Russian Federation, and his Commissioner for Children's Rights, Marieke Lvova-Belova, Russia has escalated its deportation and forced relocation schemes, now using the pretext of sending children for health and recreation purposes, taking them thousands of kilometers away from their homes. Russia employs programs such as Region Leaders Initiative and the Useful Holidays Program. The practice of summer deportation continues even with the new school year, which begins on 1st of September 2024. For example, children from the Kherson region recently participated in the so-called Games of the Peoples of Russia, held 10,000 kilometers away from their homes on the shores of the Japanese Sea. Russians systematically place children far from their homes, their language, their history, and culture. In Russia, approximately 15 programs have been created for children of all ages to re-educate them, instill propaganda narratives in their education, and introduce military components. Russians representatives call pro-Ukrainian sentiments in children such a virus that must be eradicated, and they describe their re-education programs as medicine for Ukrainian ideologies. The experience of returned children shows that they are being systematically indoctrinated to become new Russian citizens who will identify as Russian and be ready to die for Russia. The ultimate goal of physically displacing Ukrainian children is to initiate a chain of changes aimed at assimilation and the destruction of their Ukrainian identity, so indoctrination. Children are taken from their parents and placed under the care of Russian families if they do not attend Russian schools or refuse forced passportization. A key point in this context is the recent report by Yale's Humanitarian Research Lab, which documented over 300 cases of illegal adoption of Ukrainian children, which were deported to Russia and adopted in Russian families by Russian citizens. Moscow deliberately complicates the process of verifying these children and ignores our requests for repatriation with their families. All of this constitutes a crime under the Genocide Convention and the Rome Statute and may be considered as a crime against humanity. Despite all the difficulties, thanks to the joint efforts of government authorities, the state of Qatar as an intermediary in this process, and international and civil organization, 1,172 children have been returned from nearly to 20,000. Ukraine continues to seek effective legal mechanisms to hold Russia accountable. To this end, President Zelensky initiated the Bring Kids Back UA plan. Under the initiative of Ukraine and Canada, the International Coalition for the Return of Ukrainian Children was established. This coalition unites 41 countries and the Council of Europe as a participant, working on the physical return of children and rehabilitation and integration projects. Work is also underway within the framework of the first point of the peace formula, which envisions the release of prisoners of war, civilian hostages, and children. The Ombudsman is responsible for this area too. Under the President's initiative, the Child Rights Protection Center was established. At this center in which I am talking to you, investigators from the ICC, the Prosecutors General's Office, and other governmental organizations document war crimes against children, conducting interviews in line with child-friendly justice standards. This CRPC center is also a unique place to launch reintegration processes for children, assesses their needs, and provide psychological support. The children who have been returned and those still awaiting for returning are usually victims of injustice and the violation of their very existence. Their recovery is prolonged and requires significant effort, as the trauma inflicted by Russian practices is difficult to heal. It is a very long process, and these children, as innocent victims, they deserve that every Russian criminal responsible for tearing them from their families and attempting to erase their Ukrainian past while imposing a Russian future be held accountable. International support and pressure remains the only mechanism that can compel Russian Federation to adhere to its international obligations under the Geneva Conventions and like the whole international humanitarian law. Otherwise, impunity will set a dangerous precedent, putting not only Ukraine's future at risk, but the safety and rights of children worldwide. Thank you.
Thank you very much, Viktoriia, and thank you for not only giving us the numbers, but also for giving the numbers, but also bringing really the reality of what these children actually live through when they live under occupation or if they are deported to Russia. And it's a very good segue into talking about legal accountability avenues and what might be possible and what do we have under international law in our toolbox to actually start talking about how to bring perpetrators accountable. So I'll give Marieke the Hoon the floor. Please go ahead.
Who are undergoing this this horrendous crime and so very, very many other crimes. I heard you announce me also with my affiliation as honorary appeals prosecutor, and of course then I must say that I'm here to speak not on behalf of the prosecution office, but as a scholar, as a professor of the University of Amsterdam. For legal avenues, the law, legal treaties, what law applies, then the first question is, of course, what is a child? What are we talking about? Well, there's a Convention on the Rights of Children, the CRC, that in its Article 1 says that for the purpose of the present convention, a child means every human being below the age of 18, unless, And so what it says is there is no further specification. It's a negative formulation. It says that everyone that is not 18 is a child. And so we're talking here not just about small children, but we're talking about every human being that is below the age of 18 that is undergoing this kidnapping, forcible transfer, deportation, and so forth. So to start with the legal avenues, the CRC human rights mechanism, of course, this amounts to all sorts of human rights violations, and most particularly the Convention on the Rights of Children. And there are monitoring mechanisms. There's also the European Court of Human Rights, and you probably know better, but I believe that this, the abduction, the kidnapping of children and transfer is also part of an ongoing procedure at the European Court of Human Rights, because these abductions, kidnappings already began in 2014. And so, of course, Russia has withdrawn by now from the European Court of Human Rights, but everything that Russia has done before that withdrawal was effected still falls under the scope of the European Convention of Human Rights. And in the Convention on the Rights of Children, there are all sorts of protections for children, because by now, international law has neglected children for a long time. But by now, we are catching up, and the Convention on the Rights of the Children recognizes the protection and the rights of children, including survival rights, development rights, and also participation rights. And there are also provisions, Article 38 and 39, that focus particularly on the rights of children in war and what states must do to protect children, especially protect them, which, if you read them, makes it even clearer what is not being done here by Russia, or what is being done. And so the development, I already said, children have a very long time been the neglected part of human rights law and international criminal law. And in international criminal law practice last year, Cecile Abtel, for those that are interested in the topic, wrote a very good book where she, so it's Atrocity Crimes, Children, and International Criminal Courts, Killing Childhood, in which she also explains that the practice of international criminal law at the beginning didn't really talk about children, and also in the Tokyo and the Nuremberg tribunals, the children were quite absent. And in more recent tribunals, particularly the Sierra Leone, a special tribunal, they started focusing on children. But then in those early years, you also saw that by focusing on a particular crime, so child soldiers, there was actually a neglect or marginalization of all the other crimes that children were undergoing. And of course, particularly also the girls that were victimized like in sexual abuse, exploitation, and enslavement, and many other crimes. And so war is particularly grave on children, and there are also particular crimes that affect children. And so I think it's also important in that light, in this sort of like from going from not really thinking about how war especially affects children to a development of practice that we now see with the ICC, also the meaning, an additional meaning of these arrest warrants. So I think for that reason, because the ICC has limited resources, and so it must choose, and it tends to choose in recent years emblematic cases. So think of Al-Mahdi with the destruction of the mausoleums, cultural heritage. At the moment when cultural heritage all over, like for instance in Syria and Afghanistan, was being destroyed, this was an important marker. And also with starvation in Gaza, while a lot of other of these crimes were occurring. Here we see children on such a massive scale being abducted, and therefore not, I think, a surprise that the prosecutor chose this as the first case to issue arrest warrants for. But it also, the stolen children also really undermines that argument of self-defense, that this was self-defense against NATO, the entire aggression. Because how do you explain that? What do the children have to do with this? And it also strengthens the argument that this is really a fight not against NATO or against a danger, an attack, but against the people, against the children, and against Ukraine as an identity, as a nationality. So that also opens up the question whether this is genocidal intent. And I believe that my colleagues from OSINT for Ukraine will also speak on this more, but I'll mention some more. So how are children protected in international humanitarian law? Well, they're protected as civilians. All civilians are protected, particularly in the 4th Geneva Convention. But there are also specific additional protections for children there. And then there's the additional Protocol 1 that in Article 77 adds to the earlier Geneva Conventions that children shall be the object of special respect and shall be protected against any form of indecent assault. The parties to the conflict shall provide them with the care and aid they require, whether because of their age or for any other reason. Well, it's quite the contrast to what we see happening in Ukraine. And of course, when Russia is claiming that it's protecting the children, that it's evacuating them for humanitarian reasons, this is also quite cynical because, and they know this because they are a state party to the additional Protocol 1, in Article 78 it says the following about evacuation of children. Namely, that no party to the conflict shall arrange for the evacuation of children other than its own nationals to a foreign country, except for a temporary evacuation where compelling reasons of the health or medical treatment of children, or, and this is of course where the whole health evacuations go, or except in occupied territory, their safety so require. Where the parents or legal guardians can be found, their written consent to such evacuation is required. And if these persons cannot be found, the written consent to such evacuation of the persons who by law or custom are primarily responsible for the care of the children is required. Any such evacuation shall be supervised by the protecting power in agreement with the parties concerned. There are rules for this, and they require different things than Russia has been doing, or so what we see. And there's additional rules and all sorts of things that whenever an evacuation occurs pursuant to paragraph 1, so what we just saw, each child's education, including his religious and moral education, as his parents desire, shall be provided while he is away with the greatest possible continuity. And so absolutely not a change in the type of education or a brainwashing program, and so forth. It's also important that the information for the child remains with the child and is not, of course, replaced with a new identity, as we see here happening, new documents. And so you see in additional Protocol 78 all these requirements. Then international criminal law. So we talked about the ICC already, and the ICC has first arrest warrants were for Putin and for Marieke Lvova-Belova. And they issued, I don't know whether you can read, but they issued the arrest warrants, at least for now, under these two war crimes, Article 8, 2A7 and Article 2B8. What they say is it's prohibited to forcible the unlawful deportation and transfer as a war crime. So either recognized as a violation of the Geneva Convention or any other international humanitarian grave violation. And so these were first issued. And what is important to know about that as well is that the ICC, the prosecution, can add more charges, more counts later on. So it could be that this is also accompanied later on by the charge of crimes against humanity and perhaps even a charge of genocide. And I'll discuss those in a minute. One of the reasons, so of course there can be all sorts of legal but also political reasons why the Office of the Prosecution would decide to not do that. But I think in the practice it's important to realize that when these arrest warrants are issued, and particularly also with this arrest warrant, there was a lot of urgency, haste involved. The world was asking for a sign, for the prosecution to say something, to set norms, to communicate that the world was watching, or at least some, the ICC is. And so then I think from all the crimes that you can charge in what we see, the war crimes, these crimes are the clearest and probably the easiest. You need to prove that it's an international armed conflict. Well, that's quite easy to prove in this situation with Russia invading Ukraine. And for crimes against humanity, it's a little bit more complicated. I don't think impossible at all, but you need to prove more elements, that it is an attack upon a civilian population that is widespread or systematic and pursuant to, etc. So, and for genocide, it becomes even more complicated because you need to prove the specific intent. I'll show these elements in a minute. And so what I can imagine, but of course don't know because I don't work in the prosecutorial office of the ICC, Gabriele's partner does though, what I don't know is, you can quiz her at the drinks, is of course that perhaps, but I would assume that this was the way to do it quickest, and that then in the meantime, until the next steps are taken, further evidence is assessed to see whether they can also make a convincing case for some other charges. So that will remain to be seen. Genocide. We already heard Viktoriia Pasik talk about genocide, and I know that my colleagues from OSINT for Ukraine will discuss genocide more. So therefore also some of the elements as a refresher for probably most of you, and as an explainer for some of you that are less familiar with international criminal law and international law. Genocide, the crime of genocide in the Rome Statute is pretty much a copy-paste from the 1948 Genocide Convention. And it said that in the present convention, genocide means any of the following acts committed with the intent to destroy in whole or in part a national, ethnical, racial, or religious group as such. And then we see killing, causing serious bodily harm, deliberately inflicting on the group conditions of life calculated to bring about its physical destruction, imposing measures intended to prevent birth, and then number E, and that's what we're talking about today, forcibly transferring children of the group to another group. With genocide, it is important to realize that there are four, as you can see, there's four key elements. There's three of them, and the fourth is actually specifically for the ICC. That's the contextual element, that they only focus on a pattern of conduct. So there's a certain scale, a certain threshold to limit what the ICC will prosecute as genocide, but it could also be genocide. Anyway, legal details. The three other ones are important here. So is it a protected group? So is it a national, ethnical, racial, or religious group? Here it's really clearly the Ukrainians are a national group. whatever some other people may think or say about that. The second is the underlying acts, and I just called them out, and we're talking here about E. And with that, it's important to realize that cultural genocide, there was a lot of discussion when the Genocide Convention was negotiated, and a lot of the drafters wanted cultural genocide to be included. So the focus on eradicating also the culture, the identity of a group, rather than the physical destruction in whole or in part of the group. The majority was against that, or the powerful, I must say, were against including cultural genocide. And the inclusion of E, so the forcible transferring children, was a compromise for that. So it comes close to it, so that if you are objectively transferring these children from one group to another, you are also eradicating the future of the group, because the children, of course, are. And so here are some of the elements. It is not just limited to physical force, but also to threats, and that's important. So in that sense, you don't need to prove force as such with these abduction of the children. And psychological oppression can be part as well. In the elements of crimes, for those that want to read more and do more, in the elements of crimes, of course, you see more details on this crime. It's the least developed act of those 5, or forcible birth is also, well, with Rwanda a little more. There is not a lot known yet about this crime, and this makes it also difficult to know exactly how the jurisprudence, the case law, is going to crystallize. But I think that there's, and we'll hear more, there's quite a case here to argue that. If, of course, and that's the most important element, or at least the most problematic element often for genocide, if the requisite specific genocidal intent is there. And that is a double intent. It's not just the intent on committing the crime, but also that that crime is committed with the specific intent to destroy that group. So is it for all sorts of humanitarian reasons or other types of reasons, or is it really to undermine the Ukrainian identity and destroy the Ukrainians as such? Then crimes against humanity, I already mentioned. So it's the part of a widespread or systematic attack directed against any civilian population with knowledge of the attack, and deportation or forcible transfer is part of that as well. So in that sense, what we're talking about also fits the elements of crimes against humanity, possibly. Of course, all the evidence need to be assessed properly by proper prosecutors and judges. So what we've seen so far, the suspects at the ICC are 2 leaders. It's Putin and it's Lvova-Belova for this particular crime. And Putin, and both of them are for having committed the acts directly, jointly with others and or through others. But Putin also for what we call superior responsibility. So failure to exercise control properly over civilian and military subordinates who committed then the acts, or that he allowed their commission and who were under his effective authority and control. But there are more suspects. There are also a lot of mid-level suspects, lower-level suspects that may also be prosecuted. And they may be prosecuted in Ukrainians' domestic courts, and we can try and support that as best as we can as the international law community, and also prosecutorial cooperation networks. And they can be of a lower level than these highest leadership. They can be also for co-perpetration or aiding and abetting. And the difference is, like, the more involved, the more substantial your involvement was. Per country, it differs a little bit on how modes of liability really crystallize out. But in essence, it's if you're really part of the commission of it, you can be prosecuted for co-perpetration. But if you really support the commission, then there's also aiding and abetting. And if we hear the numbers of the people, of the children that are being abducted, this is not something that just 2 people or even a dozen people can do. There must be so many people involved in abducting these children, taking them away, and so forth. So the kidnapping, the transport, the rehabilitation camps, creating the new documentation, and also putting them up for adoption. Lots of people involved. And aside from the Ukrainian domestic courts, we also could possibly, at foreign domestic courts, also prosecute those under universal jurisdiction. So universal jurisdiction means that prosecutors in, for instance, the Netherlands and other countries can use their domestic courts to prosecute suspects of international crimes, of crimes recognized as under international law. And as we've seen by all the other slides, this is really a crime recognized under international law. So they would be possible to prosecute, but only if the suspects would be on our territory. So this is something that really limits universal jurisdiction, at least in practice. There's no real legal argument for that. And Belgium has, for instance, for a while had a more open, absolute interpretation of universal jurisdiction. But that means that your courts will be used for a lot of cases, and so they limit it. And I think, as far as I know, every country has limited universal jurisdiction in that sense. So other states can do that, but the availability is important. And of course, all prosecutions require evidence. And that is a bridging to my colleagues from OSINT for Ukraine. And the evidence is quite clear for those two individuals because they talked about how they were rescuing children. And also on the website of the president of Russia, it's quite they're quite proud and even bragging about the numbers, perhaps. But our colleagues are doing amazing work to also gather a lot of evidence for the mid-level perpetrators.
Thank you, and thank you for thinking of so nicely bridging to our next speaker. I will ask to go back to Zoom. Yes, we are ready. And I will hand it over to Natalia, who will talk about the evidence and the communication that OSINT for Ukraine prepared for the ICC. Go ahead, Natalia. You have the floor.
Thank you very much, Gabriele, for moderating the panel. Thank you, Asser Institute for having us today. And thank you all for joining this critical discussion. As we're tackling the unlawful deportation of Ukrainian kids to Russia and searching for available avenues and pathways to accountability. I'm here today representing OSINT for Ukraine. As it was already mentioned, a group of dedicated professionals committed to investigating and documenting international crime violations, as well as searching for available avenues of accountability. And our focus today is on one of the most heinous international crime violations, which is unlawful deportation of kids, Ukrainian kids to Russia. And this crime, as it was already mentioned before, is not just a crime attacking families and children themselves. It is an assault on Ukraine's identity and future and threat to international peace in general. My goal today is to walk you through our work, in particular our recent ICC communication. And I would like to highlight, as it was also mentioned, the importance of holding all perpetrators accountable, not just those at the very top, but middle management and lower management perpetrators as well. So on January 17th, last Friday, OSINT for Ukraine submitted a formal communication to the International Criminal Court under Article 15 of the Rome Statute. We've already discussed some of the available avenues of accountability, and ICC, of course, is one. Article 15 of the Rome Statute enables states, individuals, civil society actors in general, like ourselves, to submit a formal communication, submit evidence, and urge the prosecutor to investigate said violations. And we've decided to build upon existing investigation cases. I'm talking about Vladimir Putin, Lvova-Belova, and go a step further and extend justice beyond the top-level leadership, go further and focus on middle management perpetrators. So, as it was already mentioned, the forcible transfer of children constitutes under the Rome Statute either a war crime or a genocide. In our communication, we've indicated that it constitutes genocide under Article 6 E of the Rome Statute, which is an act committed with intent to destroy in whole or in part a national, ethnic, racial, or religious group. And in this case, the evidence we've provided shows a systematic effort to forcibly transfer Ukrainian children to Russia, erase the Ukrainian identities, and integrate them into Russian society. And this crime is extremely complex. In the course of the investigation, we came across networks of individuals and organizations cooperating with one another to carry out illegal transfer of kids. But for the purpose of this particular communication, we focus on 5 different individuals that I would like to mention shortly. These are Alexei Petrov and Alexei Gazarian, both working very closely with Lvova-Belova at the Office for Children's Rights Commissioner. They facilitated the illegal transfer of kids themselves. They welcomed the kids. They have been very available on social media and official channels as well, supporting the entire initiative. Then we have Anna Kuznetsova. She's a former Children's Rights Commissioner and current State Duma deputy. She has been lobbying unsuccessfully, unfortunately successfully. She managed to change the adoption laws in Russia, which allows now in a very easy and fast procedure adoption of Ukrainian kids by Russian adoptive families. She has been also very outspoken online and on her official channels when it comes to the support to the child trafficking scheme. And then we have 2 governors, Andrei Vorobyov, Moscow Oblast governor, and then Andrei Chibis, governor of the Murmansk Oblast. Both of them helped with facilitating the arrival of children. They welcomed the kids themselves. They were searching for the best adoptive families in Russia in their respective oblasts they could find. And again, they have been available and active on social media and official channels when it comes to supporting the initiative in general. And each of these individuals contributed to well-coordinated plan. And under Article 25 3C, as we've already mentioned, available modes of liability. In our communication, we've indicated that they have their actions met the legal standards for aiding and abetting genocide under the article that I've mentioned, because they provided the administrative, the logistical support, the moral support needed to carry out these crimes. As it was already mentioned, the legal transfer of kids itself started back in 2014. However, it intensified with Russia's full-scale invasion back in 2022. And we are currently talking about huge numbers that Viktoriia managed to provide. In our communication, we've indicated the number as of April last year, which was over 19,500 kids trafficked from Ukraine to Russia. And the evidence we've gathered indicates that these children are being issued Russian passports, Russian documents. Their names are being changed. They are being taken from Ukraine to Russia, being put into Russian families, Russian schools. Some of the kids, especially older, aged 15, 17, are being put in so-called rehabilitation camps. And we've unfortunately came across some evidence that suggests they might have been victims to sexual violence as well. This entire communication that we've submitted last Friday had 2 main objectives. The first one, less important one, I'll start with this one, was, as our name suggests, OSINT for Ukraine, we utilize OSINT, open source intelligence, to gather our evidence, which is the topic that my colleague Deniz will cover shortly. Since the ICC has already opened investigation and issued arrest warrants against Putin and Lvova-Belova, we wanted to straighten the already existing case with the OSINT evidence that we've gathered. That was one of the objectives. The second one, more important one that I would like to highlight was going a step further and making sure that we extend justice beyond top level leadership. Because while international attention has rightly focused on top level perpetrators, accountability must go deeper. And going after Putin and Lvova-Belova is a vital first step. But while investigating the illegal transfer of kids, as I've mentioned, we came across networks of individuals, organizations, authorities. This is extremely complex. It requires a lot of collaboration, requires a lot of administrative, logistical support, lots of funding as well. This is not something to be carried out by two top level leaders only. That's why in the course of investigation and while analyzing the evidence, we've decided to go a step further and focus on middle management. Because in fact, when we look at the entire child trafficking scheme, these are the enablers, the people who actually turn plans into reality. And we found it extremely important to investigate their violations in the first place and then search for available avenues of accountability to hold them accountable. Now, of course, the ICC is one pathway to accountability. We believe that complementary efforts such as domestic courts in Ukraine and universal jurisdiction that was already mentioned are extremely important. They provide another avenues for prosecution, but for the crime like this, crime of this magnitude, especially since it falls under the jurisdiction of the ICC, we've decided to utilize the Article 15 of the Rome Statute, which allows us to submit our evidence, and we hope for the best outcome. Now, to conclude, I want to reflect on the gravity of this issue. The deportation of children is, as I've mentioned at the very beginning, not just a crime against children and their families, but it targets Ukraine's future, Ukraine's identity, and international peace in general. Fighting for justice is not easy, it is not quick, but we at OSINT for Ukraine are extremely committed, and we want to encourage other individuals and civil society actors to continue supporting these efforts. By holding all perpetrators accountable, not just top level leadership, but middle management as well, we try to honor the victims. We try to prevent future violations, and we reaffirm our commitment to the rule of law as much as we can. Thank you very much.
Thank you, Natalia, for your insightful and I think all-encompassing intervention. And it's really important to keep reminding ourselves of the scale of the issues, not just the numbers, but also the composite crimes that surround forced displacement was already mentioned by Viktoriia. I will now hand it over to Deniz as our last speaker. Please, Deniz, you have the floor.
Thank you very much for that. I want to thank the Astor Institute and the Ukrainian Embassy in the Netherlands for hosting this event. I would like to thank my colleague Natalia as well for presenting the legal arguments of the communication. Today now, I will be presenting to you the evidentiary part of accountability. You can talk about legal avenues all day, but if you can't get the evidence into the courtroom, you're stuck. So first, I'll explain the investigation process, how it went, and give a little background about OSINT for Ukraine in the process. And then I will talk about the general challenges of such investigations, especially from the perspective of civil society organizations. Because as OSINT evidence and OSINT proliferates, the issues don't diminish, they also proliferate. So, as a start, OSINT for Ukraine conducted this investigation with in mind of the intelligence cycle, investigation cycle that is pertinent to OSINT. OSINT is a process, it is not a product. So open source intelligence is the analysis and is the collection and analysis of open source information. So for us, it had to be from open sources. Luckily, as the speakers have mentioned, there has been a lot of information put out by the perpetrators themselves, both of victims and of their complicity into this. So the collection part was not the hardest here, specifically speaking about the perpetrators. When it comes to the victims, it was a little harder, and our focus was not on that. We believe that when children are victims, it should be handled very sensitively and by official bodies in a more careful manner, such as the ICMP, Ukrainian Prosecution Office, and others. So the main types of evidence that we found were social media posts, which were the primary sources of evidence, posts on Kontakte, Facebook posts, official government websites, the Kremlin, the Duma, the decrees, and the Child Rights Commissioner's websites. They all were captured with full page captures, URL codes, evidentiary files were created for these. And then we used a lot of secondary publications, online news publications, Ukrainian, Russian, Western, also Telegram posts by the Ombudsman were also utilized in our communication. An important part about collecting such potential evidence, it's verification of information, both contextual verification and technical verification. So contextual verification, we need to verify whether the video, the image, the text is genuine. This is done by proximity to reality principle usually as a basic methodological principle. So in essence, is this logical, realistic to happen, and did this happen? So we also cross-reference with other sources to see, to make sure that we have the right information and it's reliable. Then technical verification is making sure the video, the data is not played around with. And that is a very important process for chain of custody and provenance principles. Yes, so that is the investigation part. And mind you, a lot of NGOs and civil society organizations do this. We did this, we're a group of young professionals who volunteer our time for this, and we do it pro bono. So we bring expertise from all walks of life and other professions that we do to be able to have a network of experts, specialists, students, volunteers, around more than, I think, 70 people who volunteer their time to be able to do such things. And our size and collaborative nature of OSINT, with the many IHL, ICL, OSINT experts there are, it makes it possible. So, moving on to general challenges during search of illegally displaced children, and in general investigations, there's two focuses: identification of victims, identification of perpetrators. And they're both crucially important, and without both, you don't have a case. And in general terms, when you're looking for victims, age is a crucial factor, not just putting it in a legal category under 18, but also when you're trying to find, search for kids that are very young. How many years has passed since the full-scale invasion? It's going to be third year, right? And kids grow up fast. Their bone structures change, face structures change, and this makes facial recognition harder. And even if facial recognition is successful, that AI and that software will have to be proven in court. So there's another issue. Then finding of real surnames, victims, age of victims. Then you have here, you think if the victim is older, it's easier to find. Correct, if you find them. Here, specifically talking the remit of this investigation, when you find such kids, you realize that they are usually the ones targeted by re-education efforts the most. Younger kids, unfortunately, are more susceptible, changeable. Therefore, it's a double-edged sword age. You think the higher the age, easier to find? True, but not always. Especially when they are around 17, 18, kids are also drafted. Their social media access is also taken away. They change their surnames, these kids sometimes, either forcefully or themselves. Then corroborating this takes a lot of time. younger kids don't have their own social medias. But as I said, we focused on the perpetrators instead of the victims in this one. So talking about perpetrators, the hardest part would be textual semantic analysis, proving intent and etc. But collection was not. There was plenty of material, and I would say the issue was that there was too much material. Hundreds of hours of material that they published with the kids saying, oh yeah, we had this humanitarian mission, oh yeah, we did this law passed, etc. So it was a lot of effort to go through this, and it was a team effort. In general, I also want to mention NGO roles in participating in such investigations and evidentiary hardships that might bring, both domestically and internationally. So there are a lot of NGOs that are helping Ukraine investigate international crimes, including this crime. However, a lot of these OSINT experts will in the future need to be recognized as either experts or specialists under Ukrainian law. Well, there is a specific law in Ukraine that requires someone to be an attested forensic expert, which means if you have a foreign forensic certification, sure, that could be translated. However, with a lot of OSINT specialists and experts, the experience gained is usually hands-on, practical. Thus, if these persons cannot be recognized, put into the certificate of experts in Ukraine, they will have to be considered as specialists, which means they'll have to prove their expertise in court, something they should be trained with, something that adds cost to the investigation, and something that should be, taken care of soon. NGOs. That's why NGOs should work closer with official accountability bodies to coordinate such efforts, because in the future we will see this issue come up again. Secondly, the use of AI. There's been a growing use of artificial intelligence in the world of investigations, both for searching databases, facial recognition, and so forth. There are two types of AI. Again, I'm not speaking from a technical background, but two types that I know of. Explainable and non-explainable AI. So explainable AI is how the internal mechanisms of that AI works. Non-explainable AI, and unfortunately a lot of the tools that are used are non-explainable. You can't explain how it works, because a large language model, you teach it how to learn and then it does it on itself. So one cannot explain it. And then you have the issue of who do you bring to court to interpret for the court how an AI works? The programmers, the person who used it who's an expert, because it requires a lot of interpretation and a lot of technical acuity. Finally, I'd like to mention the issue of fragmentation of OSINT efforts, or the overproliferation. There are a lot of OSINT groups in Europe and internationally doing this work. And we've seen that publications, just publishing investigations or reports, we found these many kids, we have looked into this, is not always effective. And sometimes publishing victims' information might be counterproductive by NGOs. That's why closer collaboration with official accountability bodies is another important point. And this is to say that the burden is not only on the NGOs, it is also on the official accountability bodies to incorporate these NGOs, to talk with them, to communicate with them, to coordinate with them better. Also, an important point is the investigations that are done by such NGOs. ECHR has been mentioned in this panel, and if you know the M817 case, it was mentioned that the M817 case proves that official accountability bodies still should reverse engineer the investigations that they receive from NGOs. As Bellingcat's information was cited there, it wasn't directly sent to court as a report or evidence. And this is an important point because this still applies. Therefore, proper documentation, chain of custody, and coordination between CSOs and official accountability bodies will ease this burden. Thank you very much.
Thank you very much, Deniz, and thank you to all the speakers. We will now move on to the Q&A session. Our colleagues in the back have the microphones, so please do wait until a microphone comes to you. Otherwise, Natalia online cannot hear it. And Natalia, you are back on the screen as well, so that you can participate in the Q&A. Does anyone have any questions, or would you like me to use the moderator's privilege and ask the first ones? Yes, I see a hand in the back.
Thank you. Two questions. It is on. The first is for the first speaker from the...
She's no longer here, unfortunately.
Then I will ask Deniz.
Yes.
Okay. Who is the accountability body that would be propagating the rules regarding each NGO this is the way we have to do it to ensure its admissibility at a later point in time in court? Is that a Ukrainian bar association, the judges, the legislature?
I couldn't say that it's a legal and political question, but what there is currently available in international standards. So there is a wave of standardization and systematization of how OSINT is conducted. So yes, coordination is needed, but NGOs have also stepped up their game. The Berkeley Protocol on Open Source Investigations, Global Rights Compliance BIS Manual, Bellingcat GLAN Manual, and Leiden DDE guidelines all, if they're adhered to, make a fine investigation. And yes, definitely. So NGOs should follow these guidelines to the T, and these guidelines should be more unified and standardized. And then, of course, you bring up a good point about institutionalization of the discipline of OSINT. Then, of course, there's debates on that. There is open source investigations, open source research, OSINT, so the semantic debates, but also purposeful debates, and how this unification would look like, because OSINT or open source research, both of these fields in the civil contexts like and maintain their democratization. So institutionalization of this should be not only a regional, national matter, but an international matter that respects the work the practitioners do, but also make it applicable in the courtroom. So something in development or should be in development.
Do we have other questions? Don't be shy. Yes, please.
Thank you for the presentations. I'm just curious a little bit about who is adopting these children in Russia. If there are 20,000 children being deported since 2022, that implies a huge number of Russian families are also complicit or unknowingly complicit in these removals. And I'm wondering how far accountability efforts can go in relation to persons who are adopting such children.
That's perhaps Natalia? Yeah, I think so. I would think.
Yes, thank you very much for the question. So while investigating the illegal transfer of kids, we came across families and individuals who are influencing others within Russia when it comes to adoption of Ukrainian kids. And we came across lots of families who make a living out of adopting kids. There were several individuals who we've managed to access their social media, or there were interviews being published with them who genuinely make a living by taking the money from the government that comes with each child they adopt. And these are not necessarily Ukrainian kids only, but these are families who have adopted even 15 children. I remember there was a lady, I cannot remember the surname, but there was a lady who has adopted 15 or so children, and she has been advocating online for other families to adopt children as well. Again, these were not only Ukrainian kids, but in general families who make a living out of adopting others or foster families. And there was, and I believe still is, an ongoing initiative online that is targeting potential families within Russia and making them adopt Ukrainian kids as well. When it comes to accountability, I do not expect accountability to go that deep. But yeah, I just don't. And this was not our focus in the first place. We wanted to investigate middle management and not target these families as in the just no. But indeed, there is. I don't know how it will be, whether or not it will be a subject of domestic prosecutions in Ukraine. Perhaps it might have been. I don't have knowledge whether or not it is currently ongoing, but I don't expect prosecuting these individuals, these families adopting children at the ICC or this level.
Yes, Marieke, please add. Thank you, Natalia.
Yeah, to add to that, because it's indeed a really interesting angle. It is required, and I would imagine that not every family that's adopted really has the knowledge and intent. So there's that. It could be that some, or perhaps even more, that are making a living out of it, but I think it depends on that also, like whether they have the knowledge and intent. And then there's indeed the who would prosecute, because normally with crimes you have your normal domestic own prosecution service, but I don't think that Russian prosecutors are really focusing on this one. And so then it's up to, will Ukraine be able to do that? Will other countries be able to do that if, for instance, these people would travel? I don't think they might travel so much outside of Russia, so that already limits universal jurisdiction. And I can imagine that for Ukraine, there's going to be some really tough choices in prioritization, who you prosecute. So there could also be that maybe when it's not so sure whether these families were so aware of the whole malicious intent behind the kidnapping, that would fall a little lower on the priority or off that priority list. But legally speaking, yeah, it could be that some families that make a business out of it are aiding and abetting.
Thank you, Marieke. I saw another hand. Are there any others? Yes, maybe we can take both of these questions.
Thank you, first of all, for the very insightful discussion. I was wondering, you've mentioned a few times that the number of 20,000 children is the number that has been on record since the full-scale invasion in 2022. And I was wondering, a few times you've also mentioned 2014, the initial act of aggression, and that the deportations have been ongoing there since then as well. And I was wondering whether the period between 2014 and 2022 has somehow impacted following the deportations now and trying to track them and keep the evidence, etc. Has it been helpful in some way, looking back all the way until 2014? Were there some insights from gathering evidence from that period, from before 2022?
We'll take the next question as well, and then I'll give you a chance to answer.
Hi.
Yeah, this is for Natalia as well.
Thank you so much for that very interesting lecture. So it was a question bouncing back to what was asked just before. I was wondering, to what extent were there misinformation campaigns in Russia where, families are not actually complicit but think that they're actually aiding, saving children that, maybe thinking that they're, whose families have been killed on the front? Is it possible to ascertain whether parents are aware or not of what's actually happening? Because I'm guessing there's a lot of propaganda, a lot of misinformation maybe going on as well. And you said that some families are active on social media, but to what extent can we realize that the information that they've received is actually, pertinent to the situation, and whether or not they've been kind of misinformed, or whether they exactly know what's going on? That was my question.
Yeah, so perhaps I'll hand over to Natalia and then Deniz. And
Mm-hmm.
to add?
I believe most of these families are misinformed because, again, as Viktoriia has mentioned at the very beginning, there's this narrative in Russia that this is actually some type of humanitarian mission that they are actually doing good. I would say the actual intent have the families who are closely cooperating with Russian authorities, who are very active online era, encouraging others to actually adopt these children. I would say they might be aware of what this entire illegal transfer of kids is. However, when it comes to regular families, and by that I mean not the ones closely cooperating with Russian authorities, I would actually believe that they believe they're doing a good thing. Because again, the propaganda and the narrative when it comes surrounding the illegal transfer of kids is extremely strong in Russia. And I do believe most of the people who are adopting the children do believe they're doing the good thing. And when it comes to the first question about the annexation of Crimea back in 2014, so the period we've investigated for the purpose of this communication is from the February 2022, so Russia's full-scale invasion, up until April last year. So we did not investigate the legal transfer of kids from 2014 up until 2022. However, there could have noticed some actions that Russia is starting doing. I believe the Train of Hope program that Viktoriia has also mentioned was introduced before Russia's full-scale invasion. They've done naturalization policy, and they have been slowly implementing legislations back in 2014 that allowed them to come to a point that we are at right now. However, as I've mentioned before, we did not investigate transfers before 2022. So this was not included in our formal communication, the submission to the ICC.
Thank you, Natalia. Deniz and then Marieke.
Thank you very much. If I may, for the last question about propaganda and brainwashing, I think an important question must be asked about a lot of Russians do not believe Ukrainians are a separate nation. You can call it, they called it brotherly nation, they said it this, that, but how do you quantify someone who's misinformed if they never acknowledge your existence ever? It is a complicated question, I would say, but also a straightforward one too, because they already did not acknowledge Ukrainians' separate existence, separate history, historical revisionism, and etc. They're taught in school. So this phenomenon, I wouldn't say is only limited to the full-scale invasion. It's before too. And absolving everyone just because they learned historically revised information, that they denied some other nations right to exist, on paper or theoretically, well, I think that should be up for debate, and more discussions should be made on this. In relation to 2014 and how it helped, I think 2014 gave us a taste of what large-scale Russification looks like. There were a lot of already OSINT projects looking into Ukraine. OSINT really had a boom with Syria, but also Ukraine 2014. And I think it's kind of ironic, but that start is the foundation that OSINTers work on today. Without that start, the work would have been harder. It would have been starting from scratch. So that would be the benefit, ironically. Thank you.
Marieke, would you like to add?
No, I'm not entirely sure, so maybe I'm saying, but I think that in 2014, the first abductions, there was some international pressure, even though there were so very little on the annexation of Crimea, but there was some pressure, and that Russia then returned either all or some of these children, but then did it again. So it's there was in the beginning, there was some sort of testing this procedure policy, if I'm correct. But then, of course, and you already mentioned, then in 2022, a real intensification and a full-scale policy.
Yes, and I think, of course, when we talk about propaganda and then brainwashing, those things may be relevant for intent, but being brainwashed into that it is correct to torture or that it is correct to displace does not actually absolve of responsibility. So I think sometimes that argument is sort of raised, but without really understanding of what it is. Maybe you
Yeah,
can
and
elaborate.
that's more complicated, because with torture you can make the argument, well, whatever, like you ought to know. And I think with genuinely thinking that you're saving children, it's a more complicated argument. So I think with this population of people where it's really difficult to assess whether they actually knew what they were doing and had that intent, therefore, that's also what I meant. Like, I would imagine that would drop off the priority list of even investigating that seriously, because it's so difficult. How do you prove that then? Yeah.
Yes, and of course, a contribution to the actual crime occurring is also different when you are at the end of the chain. But I think it's also important to discuss the whole chain, which is what this event tried to do, because a lot of justice initiatives either focus on the direct perpetrator or on the top level, and this is where we try to touch upon the whole systematicity of it.
Yeah, and exactly. And think of all those people that need to have been involved in
Employed.
And employed in the documentation and the passportization and the giving people new birth certificates. Like, that's a much harder argument to say that you were indoctrinated, you had no idea, you thought you were saving children, because you ought to know the law in that sense. And I showed you the list of requirements associated with evacuation of children, and none of this would have been required. So I would imagine that those would be higher on the priority list. Hopefully.
Do we have any more questions? Yes, we have 3 questions here. Let's take all 3 of them and then I'll let you answer.
Hi, thank you very much. I have 2 quick questions. One is a more political one, maybe. So first of all, after you made your case, how likely do you think that arrest warrants will actually be requested by the prosecutor and then be approved by the trial chamber based on your evidence? And secondly, did you also share this evidence with the Ukrainian authorities, like with the Office of the Prosecutor General? And do you think that could also be a viable approach, since you couldn't charge for the crime of genocide, right? But for other violations of the rules of customs of law and the Ukrainian law, and even if a procedure would be taking place in absentia, it could still be or fill an important role for documenting the crimes, right, and starting deeper investigations. So have you also thought about sharing this info with Ukraine, and do you think that's a good course of action doing so?
Thank you, Hendrik. Next question, yes.
Hi. I had a question regarding evidence. You mentioned a lot of open source evidence comes from social media channels. And I was wondering what the status of this evidence would be before the ICC in terms of admissibility from a legal perspective, specifically because of the relevance of the admissibility of official statements from heads of states through social media in the case before the ICJ of Ukraine versus Russia. And although it wasn't discussed at length in that case, I was wondering whether before the ICC it would also bring up similar debates regarding admissibility.
Thank you. There was a third hand. Yes.
Yes, thank you. I was wondering one thing. How are the parents, guardians, or other relatives of the abducted children involved in the legal process?
So perhaps, Deniz, on the first question of what do you think is going to happen with the evidence that you have submitted, and also on the Ukrainian authorities side?
Thank you very much. Of course, there are a lot of unknowns, and I can't speak for other parties, but hopefully it will be reviewed and taken into account. And as we said with the CHR case, hopefully reverse engineered. and they do their own investigation into this, and they come to the same conclusion as we do. And I would like to also address the social media part, if I may.
Sure.
Under ICC rules on evidence and procedure, when you analyze that and when you analyze case law, looking at open source case law, you can divide it into pre-digital open sources and post or digital open sources, because a lot of NGO reports in the 90s, in the 2000s were considered as open source as well. With new cases such as Albert Fali and etc., it changed. However, I think the current stance is that open source evidence, you can say digital evidence, digital open source evidence, have low probative weight but are admissible under the rules and procedure of the court. And yeah, that's it for me.
Yes, and perhaps a comment on whether you have shared this with the Ukrainian authorities or would intend to do so.
Natalia was mainly in charge of the drafting of the communication. However, the information there, from my knowledge, is already available to the Ukrainian side. We've used their information as well. So in an effort not to duplicate efforts, we've kept it the remit, what would be relevant to the court. But if there is such request for sharing, I don't think so Natalia would be against that.
Natalia, perhaps you would like to comment, or not at this time? Turned away from the
No further comments, but I believe there was one more question about the participation of the families of trafficked children. I want to address that by saying that at the stage of the investigation itself, we're utilizing only open source intelligence, so we're not engaged in any conversations with the victims or with their families. I believe if the communication ends up being successful, they might be engaged at the later stages of the investigation by the ICC. But at the stage of investigating the violations and drafting the communication, we have not spoken with either the victims or their families.
Yes, Deniz. Thank you, Natalia.
If I may add on to Natalia's point, and we should not have. There are more qualified people, people who can interview witnesses of victims' families that work with them. There are organizations that are dedicated to this, that are better put to talk to them, to get their information and involve them into this legal process. Therefore, our remit was presenting an argument to the court and to the world and reminding about this argument that mid-level perpetrators exist, they're there, and look at them, please.
Thank you. Thank you, Deniz. Do we have any more questions? Okay, that's first, second, and third, and I believe this will be the last round. It's coming.
Thanks a lot for this very valuable information. What puzzles me is the situation in the temporary occupied territories, actually, and the Ombudsman's office mentioned 1.5 million children that are there. Of course, information about what's happening there is more difficult to collect, so OSINT information is even more relevant. Are you specifically diving into that? What could be done in addition to the children that are deported, about which there is information? And I do think you make very valuable and relevant comments regarding experts and OSINTs collected by NGOs. Is it somehow shared with NGOs, your concern actually, and maybe also advice on how all the effort that has been put in and will continue to be invested in collecting evidence by NGOs or interviewing people or whatever, but particularly the OSINT part, could be safeguarded in a way by being much more aware of the division you made between NGO people that are recognized as experts in OSINT and specialists. And additional information on that for many more actors would be very relevant, I think. Thank you.
Yes, thank you. There was another question right behind. We'll take all three and then we'll do the final answers.
Thank you for this lovely panel discussion. Since we're discussing about culpability and intent, I wanted to bring up what you thought about the idea of the case of the Russia trials for the Lebensraum program during the Nazi Germany. In that case specifically, they talked about how the intent of the SS parties to destroy individuals by creating the Lebensraum program and creating adopting children, sending them ethnic Germans to those were considered as crime by itself. Therefore, in the Russia trials, it was kind of recognized at the time that those abilities were crimes. But if you look at why some people were not indicted at that trial, specific actions of not having participated directly when they were not aware, those were not they were not indicted, but they were indicted for being the member instead. So they got a lower sentence, but they still were culpable at that trial, which suggests in this current case of discussions of the Russians that were involved with the adoption but had no intent or had completely separate intent that they were not aware of. But wouldn't they still be culpable under that standard that has been set in the Russia trials in the 1950s? Or do you think that's no longer relevant at the current moment or not?
Can you hear me
I
now?
think now it works,
Okay.
yes. I think it was for Marieke, so I think we're okay. But then for the last one, let's use the working microphone. It's behind you, yes. Yeah.
Thank you. My question to OSINT for Ukraine. What procedures, what steps you follow to link the perpetrators with the author of the social media posts to identify them as one person? Thank you.
Thank you. Short and sweet. So perhaps on the first question, I'll give the floor to Deniz.
Of course, as areas remained occupied in Ukraine, access to these locations in traditional forensic and investigative forms remains challenging. OSINT becomes more important. However, I don't know if you've read a recent article by the Center for Information Resilience, and this is also some of the things that we've also witnessed, that user-generated content is going down. Specifically, there are now in militaries commands that soldiers do not use their social media to film themselves, which means we're relying on local populations, which again can be prosecuted by the occupation powers, persecuted, I mean, by the occupation powers for revealing the truth. We're also depending more on alternative forms of open source information, more on satellite imagery, more on website publications, archived footage, which means there must be increased efforts to make sure open source evidence is archived properly in the proper manner. EXIF files are correctly managed, blockchain evidentiary procedures are used, and experts are utilized at all points to make sure, because there's a lot of NGOs that also use volunteers a lot to help geolocate stuff. We need to make sure that those volunteers are expertly coordinated, trained. This includes not only for volunteers, but specialists and experts are trained in expert witness testimony trainings in courts, international, national. Yeah, that would be my advice. And of course, for NGOs, there are already methods that they can connect to police, national police force, European police forces, such as Europol, Dutch War Crimes Unit. And I think the Ukrainian national agencies have been collaborating with organizations like Center for Information Resilience and so on for quite a while. So there are already avenues available. I think it's just after the fragmentation and overproliferation of OSINT slows down, there will be more defragmentation and centralization of efforts, and there are bigger NGOs and more established OSINT NGOs who will guide all other groups in adopting standards, using proper terminology, proper tools, and also providing resources. A lot of the issues of OSINT is that there's not enough money to use such advanced technologies for search, but also documentation. So that would be my answer to that.
Thank you, Deniz. Marieke, perhaps on the case?
Yeah. Very interesting point. I would have to look into that to really properly answer you. So apologies for that. And part of what makes it also challenging is that with regard to modes of liability and mens rea aspects, there are quite some variations between different countries, so different jurisdictions. So that also makes this a really difficult issue. And on that note, on these variations, I was also thinking of the question was posed for social media at the ICC that Deniz addressed. But this is also quite different, or can be quite different between countries. And for instance, here in the Netherlands, we've had, Deniz mentioned it, the MH17 trial, where we had, they relied a lot on social media information. Bellingcat had done quite a lot of, had done a lot of investigations. And what they did then, this was a few years ago, was that the prosecution thought, well, let's not risk it. It's quite novel. So they kind of redid all the investigation that Bellingcat did, not to discard them, but to be on the safe side. And of course, with the MH17 trial, which is the plane that was downed over eastern Ukraine by Russia, there was also the additional sort of understanding that the world was watching, that everyone from sort of the Russian angle would really try to undermine it. So let's really try to redo this. And being sent, of course, to forensic institutes. And since then, we've had some more experiences here in the Netherlands, but also some of the other countries to use like Facebook films, for instance, of ISIS fighters. And so I think the ICC is always a bit of probably the most complicated institute, because it has to really combine all of these legal traditions. And in common law countries, they have some different evidentiary law than here in civil law countries. But I would imagine that this is a development, and that we are learning from one another, and that there will probably be some increased abilities for admissibility here as well.
And on the final methodological question of linking...
Yeah, sorry, admissibility, I meant probative value, because, yeah.
Yes, I think that links to the final question. Deniz, are you going to take that?
Of course, linkage evidence, how to link a person to the account. You could do it in a few methods. If their face is available in the video, you make sure that video is authentic. It hasn't been altered, and you would do contextual analysis. What is it portraying? You verify that. 2, the accounts are from official accounts. They're linked to emails that we can corroborate that are used by the official office of said person. And then there is also metadata analysis, as I mentioned, but I think these 2 things are straightforward in the case of said perpetrators. They did not hide this, and that's the key part. They didn't need to hide this, and they're not hiding this. So while this information is available, and because day by day more and more information is coming out, we should archive this and document this properly and get on with prosecuting them, hopefully.
Yes, and I guess this would be also the questions that the defense may raise, so it's good to have a prepared answer already. I think I would like to conclude, as we have run out of time. Many thanks for all of your questions and for your responses. I think it was a very interesting evening, and I hope that I speak on behalf of all the audience. I'd like to thank our speakers. I would also like to thank our co-organizer, the IHCL platform, our events team that have been helping out with the microphones and to make everything happen, as well as our IT support team. And before you go, I would like to inform you that this year the Usher Institute is celebrating the 60th year anniversary, as you can see on the logos. There will be many events, and the next one that we have here that I will be moderating again, if you want to see my face, is 4th of February. We will have another lecture on the sensory experience of justice with Caroline Fournet and Mark Drumble. Keep an eye on our events page for other updates, or subscribe to our newsletters so that you don't miss anything exciting that's going to come this year. And thank you again all for coming. Thank you.